Hi, I'm Gail Eskridge. I would like to tell you a little bit today about why I am such a fan of mediation and arbitration. During my 30 plus years as a litigator, it became very clear to me that the vast majority of my clients wanted to get their cases resolved as fairly and efficiently as possible. With it taking up to 2 years to get to trial in Los Angeles Superior Court and even longer in some of the surrounding counties, my clients often became very frustrated and sometimes also ran out of resources to finish the case. It's for this reason that I became interested in mediation and then later in arbitration. The goal should not be to grind the opposing party into the ground and win at trial. If you have to go to trial, obviously you want to win. But in my opinion, that's not the best goal. The goal should be to resolve the case so all parties can move beyond the distractions, challenges, and costs of litigation and get back to their lives and businesses. Litigation is financially expensive, emotionally draining, and just plain time-consuming. The entire time someone's in litigation, they are reliving events which were at best unpleasant and at worst extremely traumatic. They can't move forward when they're living in the past. This is not healthy, and for clients who are paying their attorneys by the hour, it's not economical. In my work as a mediator, I strive not only to achieve a settlement, but to make the parties feel that they have been treated fairly and with respect. Why is a mediator even needed, you may ask? For years, attorneys settled cases by simply talking to the opposing attorneys. Well, that's true. But I think there are several reasons having a mediator involved is helpful. I have found one very important reason that mediation works so well is that the parties are involved in the process. They want to at least feel like they had their day in court. Almost everyone wants to be heard. In mediation, they have the opportunity to tell their side of the story and describe their feelings to a neutral third party. Another benefit of mediation over court, or even over arbitration, is that a creative settlement can sometimes be achieved. For example, in an employment case, there may be a settlement which involves the terminated employee coming back to work, maybe including with a promotion or a transfer or a change of supervisor. Maybe it involves the employee coming back to work and the alleged harasser not being there, either due to a transfer or a termination. In a real estate case, I've had cases where I had a neighbor dispute where the solution was for one neighbor to buy the other neighbor's property. That solved the problem of the dispute right away. You can, in real estate cases, you can sometimes agree to an easement or do a deed back. There are a lot of different things. Or in tree dispute cases, sometimes you just need to have everybody traipse out and look at the trees and measure the trees and look at the view and agree on a tree trimming plan and on, how high is too high for the trees. I've done that before. And there are quite a few. You'd be surprised how many disputes there are involving trees, either because of blocking someone's view or just encroaching on someone's property. In a business case, lots of creative things you can do in resolving business cases. One party could buy the other party out. One party could, buy a product line. It just depends on the case, but there are a lot of creative things you can do in resolving business cases. And none of these resolutions would be possible in a court trial or even arbitration. I mean, judges and arbitrators, they have to follow the law. They can't say, well, I want to try something different this time. Those arbitrators and judges are sort of limited in what they can and cannot do. But in mediation, since you have the parties there themselves, everyone's there, you can get creative sometimes. Not always. Sometimes it's just a fight about money, and one side has to pay money to the other side, and it's a question of how much. But sometimes you can really get creative, and things can be resolved. And while mediations are not without stress, they're not nearly as stressful as trial or even arbitration. Attorneys are accustomed to courtrooms. I mean, most attorneys like being in court. Courtrooms don't frighten us. But for a person who's never even visited one, sitting in court in the witness box and testifying in front of a judge, other parties, attorneys, and jurors, it can be absolutely terrifying. A mediation in a pleasant conference room in which parties are not even required to see the opposing side if they don't want to is exponentially less stressful than testifying in court or even in arbitration. Another huge advantage to settling a case at mediation, or to settling in general, really, is that it avoids the uncertainty and unpredictability which is present in court trials and in arbitrations. In mediation, the parties can control their own destinies. Sometimes there's actually a legitimate misunderstanding that can be discovered during the mediation, and people can actually preserve their business or personal relationships that they had, before the dispute arose. If you go to trial, any chance of preserving a business or personal relationship with the opposing party is probably out the window. I had one mediation where it was a legitimate misunderstanding. It was the sale of a business from one guy to another guy who was his friend. And there was a legitimate misunderstanding about how to value the business. And we figured that out during the mediation and resolved the case. Everybody was happy. At the end, they were hugging each other. They went to lunch together. I'd like to say that's normal. It's not. But it can happen. It's happened to me a few times. And it's great when it does. If the parties are unable or unwilling to resolve their dispute in mediation at the outset, they would be well served to proceed with arbitration rather than court, assuming they have a choice. Arbitration is a creature of contract. You can either, what usually happens is, you've signed a contract pre-dispute, which requires you to arbitrate the dispute. But you can agree, once you know you have a dispute, you can agree, both sides can agree, hey, we would like to go to arbitration and get this over, faster and more economically, rather than spend the next couple of years in court. So that is possible. I haven't ever seen that in an employment case, but I've seen that in commercial cases for sure. Just about any type of case can be resolved in arbitration if the parties agree to arbitrate. There are many employment cases in which the employer sometimes strongly insists, that the employee sign an arbitration agreement, and then when a dispute comes, the employee and the employee's attorney are resistant to arbitration. And in that case, I understand. I understand what the plaintiff's attorneys are concerned about. I think that the main concern is they think they won't be allowed to do adequate discovery. And I'm not saying that never happens in arbitration. But when I'm the arbitrator, everyone will have the opportunity to do adequate discovery. I don't, let people do ridiculous discovery that's not necessary, but everyone gets to do adequate discovery. And what that is depends on the case. And I take that very seriously. Arbitrations are much faster and more economical than proceeding in court. In arbitration, if you have a discovery dispute or need an extension or need some date changed or something, you can just email me, of course copying the other side. Or you can, arrange for a phone call, and everyone can get on the phone and discuss it. If it's a discovery dispute, usually people send me emails or, maybe attach a letter, and I'll either rule based on that, or then we'll have a phone call. Sometimes we only have a phone call. Never do we have a full motion to compel further responses with a separate statement and all that rigmarole. Not only our discovery, I guess what I want to say is not only do discovery disputes take up less attorney time in arbitration than they do in court, because you don't have to meet and confer ad nauseum, then do an IDC, then file a motion with a separate statement, then have a hearing. Not only is that a lot of work, but a lot of time passes while that's happening. It may be a couple months or 3 months from when the dispute starts to when you have a ruling. And all that time you're waiting, you may be prevented from or hindered in going forward with other discovery or with other things in the case. And once in a while, too, in my experience as an attorney, when you get the ruling, the attorneys, both sides, don't agree with the interpretation of what the ruling means. Obviously I try to avoid that in my rulings, but if that happens, again, it's just an email and I can clarify the ruling. That's another quick avenue that's available in arbitration that's not available in trial. Another benefit of arbitration is that at the arbitration hearing, at least if I'm the arbitrator, the parties can start as early as they want in the morning and go as late as they want at night. I'll even arbitrate on Saturdays, Sundays, and holidays if that's what the parties want. I would never force anyone to arbitrate on those days. But if everyone wants to, great, I'm fine with that. Compare this to court, where you usually can't start trial until after the morning calendar finishes, which could be 10 or 10:30. Then you have an hour-and-a-half break for lunch. Then you have an afternoon break, and then you have to quit about 4. So you really only get in a few hours for what's referred to as a day. In arbitration, you can easily get in 7 or 8 hours of actual arbitration time. And there's no trailing in arbitration. If I say the hearing is going to start on a certain date, it's going to start on that date. You can plan your life. You can plan your vacations. You can plan, going to your kids' school events. Your clients can plan their lives. Just that alone, I think, is a huge reason that arbitration is nice over trial. Another advantage of arbitration, and I think attorneys feel a little uneasy about this at first, because we're so accustomed to so many procedural rules, the California Code of Civil Procedure, the California Rules of Court, the federal rules of civil procedure. But in arbitration, unless the arbitration agreement says any of those rules apply, they don't. So the arbitrator can establish more common sense rules for how to handle things that are not valuing form over substance so much as what happens with some of the procedural rules that you're required to follow in court. Separate statements are a perfect example. All the rules about your margins and where your page numbers have to be and how your pages have to be numbered and how your exhibits have to be numbered. I don't care. Whatever works is fine with me. You can use whatever margins you want, whatever font you want. You can use more than one font in a document. You can use more than one color ink in a document. I mean, if you think that would make it easier to understand the point you're trying to make, I'm fine with that. So I really try to avoid those form over substance type of procedural rules. While parties don't have the degree of control in mediation, don't have the degree of control in arbitration that they would in mediation, they still have a lot more control than if they were in a court trial. For example, the parties may agree to bifurcate or trifurcate or split the case into any number of phases if that's what they want. You can stipulate to have a major legal issue tried early. So you know where you stand and don't spend 2 years working the case up only to have what you thought was a major argument or a major piece of evidence blown out the window on the first day of trial. So I've had cases where there was a very technical, expert kind of issue, where the parties agreed do a little bit of discovery, and then for me to select an expert who would opine on this one critical issue. I don't think you could do that in trial. So there are a number of things you can do in arbitration that give the parties more control than if you were in trial and limited by all of the procedural rules that judges are required to follow. Perhaps the most important reason for choosing arbitration over a court trial is because it is a lot less stressful for the parties and the witnesses. Instead of being, in a scary courtroom with a whole lot of people looking at you, it's much more private. It takes place in a conference room, and it can be a conference room, wherever is convenient for the parties and witnesses. You don't, all have to traipse down to a designated courthouse. You can do it at some of the court reporting firms have conference rooms and are great for arbitrations. The American Arbitration Association in downtown LA, of course, has a great conference rooms. There are hotels that have conference rooms. I've done an arbitration in a classroom at a university. They can, basically in arbitration, I say whatever makes sense. So that's another thing that gives flexibility and really reduces the stress for the parties. And, I've had clients who not only are they scared to testify in court, they're scared to drive downtown. They're scared to park. We have to arrange for someone to take them. And if you're, planning on where to have a conference room, you could have a conference room, somewhere that's not downtown or Century City, where it's a little more, where driving and parking is a little more sane. So, there are a lot of reasons that arbitration can be better for the parties and a lot less stressful. Well, I think I've been talking longer than I planned, but I am passionate about mediation and arbitration, and I think everyone else should be too. I would love to have the opportunity to serve as a mediator or arbitrator in your case. I look forward to talking with you. Thank you for listening.